Hey everyone, I'm Attractive Nuisance, this is Leisurely Law, and this is my foxy friend from Spirit of the North. We're here today to talk about Indigenous self-governance, so we'll be largely focused on the Canadian law side of things. Not because the US doesn't have Indigenous people, but because this is what I learned about Indigenous law from my US law school. And I don't think it bodes very well that no one there, even or especially legal professionals, talk about how the country accommodates the original people. Particularly when most of their residential schools were only shut down as late as 2007. For context, in Canada, our last residential school was closed in 1997. Broadly speaking, the legal framework of the Canadian Constitution divvies up power to the provinces and to the federal government with the least amount of overlap as is possible. The bare bones of jurisdictional powers can be found in sections 91 and 92 of the Constitution Act 1867, which outline a pretty thorough list of powers. You'll notice in section 91, subsection 24, that the federal government has power over Indians and over lands reserved for the Indians. The language of legal documents continues to refer to Indigenous tribes as Indians, or in the best cases, Aboriginals. This is also seen in how the Indian Act is still in force in Canada. Despite Indigenous matters being within federal jurisdiction, provincial laws still apply to the Indigenous people and the lands reserved to them. However, there are some exceptions to this, one of which being a provincial law that singles out Indigenous people, because this becomes unconstitutional assertion of provincial powers. For example, let's say British Columbia passes a law that prohibits hunting deer in the northern regions of the province, claiming the law is necessary to help increase the deer population in the province. But the northern regions are occupied almost entirely by members of the Shuswap Nation, who survive off hunting deer. So sure, the law applies to the whole province, but in practice, the law only really affects the Indigenous people in the province. The Supreme Court of Canada has ruled that laws like these are unconstitutional for lack of jurisdiction. I said that we'd be talking about Indigenous self-governance, but so far all I've discussed is federal and provincial governance. So in the spirit of call to action number 45 of the Truth and Reconciliation Commission's calls to action, let's repudiate the justification of European sovereignty and turn to a slightly less Eurocentric discussion of Indigenous self-governance. First and foremost, Indigenous land rights continue to be recognized under the common law and are enforceable by courts. These rights can only be extinguished by surrender or constitutional amendment that demonstrate a clear and plain intention to extinguish, i.e., it has to be super obvious that the Indigenous people no longer want a specific land right. This means that the Indigenous people hold title to land that they've occupied, and they continue to occupy, a concept that Canadian courts are still grappling with. Land rights, such as Indigenous title granting the right to exclusive occupation of the land, are the preeminent focus of Indigenous self-governance in Canada. While treaties and laws may regulate these rights, they can't extinguish them. Jumping over to the Constitution Act 1982, Section 35 is the focal point of our discussion today. It affirms legal assertions of existing Indigenous and treaty rights and acknowledges the pre-existence of Indigenous rights in Canada prior to Crown sovereignty. Section 35 protects the deep, living connections between people and land and seeks to preserve the quiet, sacred spaces shaped by memory. In practice, an Indigenous person or group can raise a Section 35 claim to assert constitutionally protected rights that may limit or override government actions. The intention of Section 35 is that when courts consider Indigenous rights cases, they also consider the history and context of Canada's relationship with the Indigenous people. The court first considers whether the government action has the effect of interfering with an existing Indigenous right, such as occupation, hunting, or travel. This includes factors such as an unreasonable limitation of Indigenous rights, undue hardship on the individual or group, and denying the rights holder the preferred means of exercising the right. These three factors inform a lot of how courts interact with Indigenous claimants. If there is an interference with an existing Indigenous right, then the court asks whether it was a valid, compelling, and substantial objective, whether the honor of the Crown is at stake, whether the Indigenous group was consulted prior to the action, whether there was as little infringement as possible to effect the desired result, and whether fair compensation is available. The issue with the court's approach to Indigenous claims of right is how jurisprudence has really narrowed the definition of an Indigenous right. There are always these hidden requirements to the challenge. For example, to determine if an Indigenous right is at issue in a case, the court develops, you guessed it, another test. Essentially, the court looks at whether the claimant has proven that there's a relevant pre-contact practice, tradition, or custom that's integral to the distinctive culture of pre-colonial society that has continued consistently enough since European contact. You can see how this could be like wandering around in a snowstorm looking for clues, and this can become even more complex if the case involves Métis or Inuit claimants instead of First Nations. The implementation of Section 35 Indigenous self-governance without Canadian government interference, like so many legal concepts, has proven easier said than done. And this is further complicated by the fractured relationship that Canada has with its Indigenous people. I've found that there's a lot of discourse in academia surrounding the traumas that the Indigenous people of Canada have suffered due to colonialism. And don't get me wrong, understanding what went wrong is immensely important. But I think the point we so often miss is that we need to move forward and heal. It is, after all, called truth and reconciliation. The truth is that colonial Canada engaged in a cultural genocide of the Indigenous people. The truth is that Canada hasn't upheld its treaty responsibilities to the Indigenous people. And the reconciliation is what we need to do moving forward. And to do that, we need to know not only what we did wrong, but what we can do right in mending the relationships with the Indigenous people. This includes understanding that any land not surrendered to Canada still belongs to the Indigenous nations. This means holding the government, the Crown, accountable for upholding the honor of the Crown and the duty to consult with the Indigenous whenever the Crown contemplates an action that will affect an Indigenous interest. And this means acknowledging that the colonial foundations of Canadian systems, like the justice system, need to be confronted and changed. It's not just theory, it's not just dusty legislation or verbose statements. It's the practical, everyday interactions that we have with our world and being able to adjust when our actions cause someone else harm. It's about interacting with our environment so that we can solve puzzles, find solutions, and unlock the secrets that bring light and beauty to all of our lives. Thank you for joining me today as we explored Arctic landscapes and sometimes equally frigid Canadian law. I'm Attractive Nuisance. This is Leisurely Law. Until next time.